The next case to come before the court is in re CT. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know, as I'll be keeping track of the time. The arguments are being recorded, so please stay behind the podium, keep your voices up, and you should not use the names of children or minors or victims. In your argument, you can refer to them by initials or generic terms like the child. The judges have read your briefs and we are ready to proceed when you are, and I would just ask the appellant, would you like to reserve any time for rebuttal?
Yes, please, 5 minutes.
Okay, very well. Then you may begin when you are ready.
Thank you.
And you are attorney Bowden?
No.
No.
Cheap.
Cheek. You are attorney Cheek. Yes, I'm sorry.
Yes. I'm ready to get started.
We are ready for you, attorney Cheek, when you are ready.
Thank you. May it please the court, opposing counsel Bodner. My name is Attorney Todd Cheek. I represent the father of the child in this case. Father is ultimately requesting that this matter be remanded back to the trial court, or preferably that his motion for legal custody be granted by this court. Father brings this appeal for 2 reasons, and he believes his position is supported for these 2 reasons. Number one is a matter of plain error. The other one is the matter of the trial court's decision denying his motion for legal custody and granting permanent custody of children's services was against the best interest of the child and against the manifest weight of the evidence. I'll start with addressing the plain error issue first. There was some question about criminal or civil plain error. It's father's position that this is a matter of civil plain error, and that it's a specifically civil plain error because within the court's judgment entry, the court is talking about the interstate compact on the placement of children, which I will use the acronym ICPC for. And with regard to ICPC, the trial court is incorrectly indicating that it's prohibited from granting legal custody to the father because his home study was not approved. Now, father lives in Michigan. Indeed, there was a home study conducted that was initially approved and then subsequently denied because he was dishonest about his drug use to the person that was conducting the home study. However, what I think is important to note with respect to the plain error issue is the trial court's indicating in its judgment entry that even if the court felt like father should have been granted legal custody, the trial court is indicating that it cannot because of ICPC. And I think the takeaway is that since the court is indicating it's prohibited from granting legal custody of the father, even if it were to find the father would be an appropriate placement, the trial court seems to be indicating that ICPC has total control over whether it can grant legal custody to the father or not. And I think that's where the plain error lies.
Did the journal entry also reference other issues with father that didn't, even if he would have done a home study with the other state, was it still a best interest analysis? Were there other issues besides that?
So I think that I think that's the very issue, Your Honor, is that, and I'm going to address those other issues. I think those go to the weight of the evidence. But as far as the ICPC is concerned, it's father's position that ICPC has no bearing on the trial court's decision to grant legal custody or not. Because if you read the ICPC statute, particularly Article 1, states what the purpose of the statute is, and its applicability is to public or private child placing agencies and supervision over the matter. It doesn't really have anything to do.
But counsel, are you arguing though that didn't the juvenile court still consider the statutory best interest factors in its order?
Yes, yes it did.
Are you saying in the first assignment of error that they got the law wrong on the ICPC? I'm just trying to figure out how that plays into us reversing the case.
Sure. What I'm, and perhaps admittedly not explaining it very well, I think the issue with ICPC is the court is evidently placing such a weight on the ICPC result that it's saying the court couldn't have granted legal custody of the dad even if it wanted to. And I think that's where the error lies, is the court has that law incorrect, because that's not what ICPC says.
Okay, but are you saying then that somehow impacted the analysis of the best interest factors? Trying to understand.
Sure, good question. And yes, I think it does. I think if, and I'm kind of segueing into the weight of the evidence issue here. When you read the judgment entry is making certain findings about what has happened. And I think that there's several inaccuracies that I'd like to point out. For example, the trial court is talking about foster parents and their willingness to discuss the idea of adoption. But that's not telling the whole story, because there was testimony from the caseworker who said the foster parents were not open to adoption. So there really is some question about long-term placement options with this child. In the same sort of breath, there's discussion about relatives. So father, my client, proposed certain relatives. Children's Services has home studies pending for the same relatives. So on one side, the trial court is critical of those foster parents that father brings up when they're talking about whether father's motion for legal custody should be granted, or his alternative request that those relatives be granted legal custody instead of permanent custody of the agency. But the trial court is ultimately granting permanent custody to Children's Services, who has an adoptive parent who's at best on the fence on whether they want to adopt or not. And then they have two relatives, the same relatives that the trial court is critical of when dad brings them up. So those relatives, by the way, had never met this kid. The child has never even seen a photograph of these relatives. And what we know about dad, and I know the state is going to bring up some faults of his, he surely had them. My position is they were very early on in his involvement in the case. And I think he's rectified any concerns about him. So the point is,
He's rectified that by working a case plan, is that in the record?
I certainly believe it has. Interestingly, sort of in the same point of the trial court, I think, failing to bring up certain things that are positive about dad, there's a findings and decision, or findings and order of magistrate that's from May of 2022. The trial court failed to acknowledge in that findings and order, it states there's been significant case plan progress. That's in May. So before that, our dad's missteps about misrepresenting his drug screen result at the end of 21, and the issues he had with the Suboxone program doctor that he was seeing, that all came to a head in April. So in May, significant case plan progress. In June, his visits are reinstated. From June on, he exercised all of his in-person visits. He didn't miss one. Now, this is from Michigan to Wayne County, so a lot of his visits were on Zoom. There were, with respect to his Zoom visits, 64 of 71 were exercised over the course of the proceedings. So, again, I'd like to get back to the trial court. I think bringing things up that weren't quite accurate.
Can we go back to what you said
Sure.
about the folks that the father had suggested for legal custody? Did he know those people?
I don't know that he knows them, but they're relatives, and he knew at the time that Children's Services was considering them as placement options.
Okay.
But the issue, the reason I'm bringing it up is the paradox is, when he brings it up, the trial court's critical of him for even suggesting these people. But these are the same people that Children's Services is considering as placement options, and the whole reason why they need to have permanent custody. My argument is, I don't doubt that a minor child deserves legally secure permanent placement. I mean, that's what the statute says. There's no debate in that. But granting permanent custody to the agency doesn't do anything for that, because the options for this child are foster parent who's on the fence and two relatives who don't even know the kid and haven't even fleshed out. And when we compare that to the dad who has a primary right to the care of his child, we know that this child, is referring to him as dad.
And I should let you know that you
Sure.
are moving into your rebuttal.
Okay, thank you. A few more comments. Thank you for letting me know that. There's a couple things I think that I want to point out in the judgment entry that lend to the weight of the evidence argument here. For example, I already mentioned the foster parents, I already mentioned the relatives. Another example of this is the trial court mentions that father took no steps to establish paternity or pursue custody or visitation rights despite knowing about the existence of the child. That's an inaccurate statement. We know from the testimony of the caseworker that father reached out to Children's Services in July of 21 requesting paternity testing. Hence, the trial court is criticizing father for something that's inaccurately stated in the trial court's judgment entry. There's also criticism of father from the trial court stating that there's a March 30th judgment entry requiring all of his drug screens to be observed. You have the record. I looked over the judgment entry again this morning. I don't see in that judgment entry where dad is required to have observed drug screens. I don't think it's in the case plan either. So again, I think we have the trial court criticizing father for something he wasn't really even required to do. I already mentioned the May 22 findings in order of magistrate, where there's a finding that significant progress has been made. That was not mentioned. In August of 22, there's a findings in order of magistrate in which the magistrate found father consistently attends video visits with the child and generally attends his recent in-person visits. The trial court also gets something wrong. It states that incorrectly that he did not submit to this hair follicle test that was ordered in May. The trial court says he didn't do it until after Children's Services filed for a permanent custody motion. That's not true either. Yes, he was ordered to do it in May, but he didn't do it right away. He did do it in June, albeit late, but the motion for permanent custody was not filed until July. So the reason why I wanted to have this oral argument is to point out that I think there's a number of things in the judgment entry that are inaccurate, and they are things that the trial court is criticizing father for not doing but you're not required of him, or they're not accurate. And I think I just want to end on this because just a minute left. Dad did not start off well, but that should not pretend that he should be ruled out as legal custodian. He got back to seeing the same counselor he was seeing before. That same counselor said no issues with him. The drug screens he was taking were only showing positive for THC. He lives in Michigan, where the use of marijuana is not illegal. This is a father who has a strong bond with his son, and the court has granted permanent custody to the agency, holding out hope that people who haven't been really shown sincere interest in adopting or had no contact with this child at all are going to pan out. That just makes no sense when we know that the dad, who had his problems, has corrected his course and has a strong bond with his son. I think the evidence supports that at least remand or grant of legal custody. I understand I'm out of time. Thank you.
Thank you, counsel, very much. Okay, Attorney Bowman.
Good afternoon, Your Honors. May it please the court, opposing counsel. Today, I believe we're presented with the issue of whether, in a case where the factors weighed heavily in favor of permanent custody, the ICPC had anything to do with the court's ultimate judgment at all, in a case where the court conducted an independent analysis of both the best interest factors and also the applicability of the ICPC to the case. And you could read either one of those analyses independently and conclude that the court correctly decided that it was in the child's best interest to be a permanent custody agency. And this also dovetails with the second issue presented, whether in a case where the factors for best interest weighed heavily in favor of permanent custody, the court lost its way or was hoodwinked or just got confused by all the issues in the case. And the agency's position, not surprisingly, is that the trial court did not lose its way in this case. Our position is that whether it's under the plain error standard, whether we're talking about a civil or a criminal plain error, that the father, Helen, can't meet either of these standards in this case because he didn't make, there appears to be no, at least in a brief, argumentation of how what the standard requires is evident in this case. The standard, so far as I understand it, is that but for the court's error, the outcome of the case would have been different. And when you read the court's decision in this case, with the analysis of first the ICPC and then the best interest factors, that's not what the decision bears out. The decision clearly shows that the judge, the trial court, believed it was in the best interest of the child to be in the agency's permanent custody, and that was, I believe, also the reason why she felt like the ICPC applied in this case, because one of the requirements for exemption is that it is in the best interest of the child to be accepted from the ICPC. And the court, in its decision, found that it was not in the child's best interest to be accepted from the ICPC. So ultimately, the agency's position is that it boils down to best interest factors. The court considered each and every one of those in this case, and it also considered some of what opposing counsel mentioned, father's early flaws. Unfortunately, those flaws carried on through the end of the case. Whatever timing inaccuracies the trial court father complied late, I might mention, with his order that he do the hair follicle testing in relations to when the actual permanent custody itself was filed. Until father filed his motion for custody in August, he hadn't made any moves up to that point to try to increase visitation or to, more to the point, there was a period from December 2021 until late June of 2022 where he didn't visit the child in this case in person at all. And that was after he had tested positive on a series of 3 drug tests at the agency. It seemed fairly evident to both to the agency and to the court that father had learned that when he came for a visit, he was going to get drug tested. And I believe that that is one of the credibility determinations that the court made in its decision, that he had perpetrated fraud on the court and that that had carried through the conclusion of the case, because there's testimony to the effect that when he had a visit in person, he knew ahead of time when that visit was going to be, so he would be able to control his use prior to that time. And he also was capable of calling off a visit.
What was the result of that hair follicle test late in the case?
It was positive for tetrahydrocannabinol. There were no other substances indicated in it.
Okay, because that goes back 6 months.
Yes, I mean, depending on what test it does, there's a 90-day look back and a 180-day look back. So depending on what it is, I can't recall off the top of my head whether it was the 3-month or the 6-month look back on that June 28th test. But I don't, even though father had no positives for other controlled substances after the point when he had his, I want to say it was December, I think 21st, 2021 test that was positive for a number of other controlled substances apart from THC. There were indications and testimony to the effect that his fiance had gotten a job with his physician, and his physician was administering the tests, and she had been manipulating the samples and sending fraudulent documents to the agency. So those were all concerns with regard to the agency and the courts in this case.
And were there questions about, or concerns about what father had disclosed to the person doing the drug assessment? Is there some question on that?
There was also a question, I believe during the final hearing in the case, Shara McKinney, I believe, was the father's therapist. She indicated that father had not disclosed his positives from November and December of 2021, and that had he done so, and that then had they been contemporary with his initial evaluation, that she would find that less concerning, but that since she was just hearing about it then, that was more concerning to her in terms of the accuracy and applicability of that initial assessment. Also of concern was the fact that father had, it wasn't the same, there was no correspondence or little correspondence between his physician's office and the providing organization that was performing his intensive outpatient programming that he completed. Also of concern was the fact that he did not initially schedule his aftercare, which was recommended for April of 2022. And he didn't re-engage with any kind of substance use disorder treatment until September. When he did re-engage, he was testing with the same providing organization that was giving him the services for cessation. Concern there, though, was that testing was random, only twice a month, and there was expert testimony to the effect that twice a month is completely ineffective to establish a baseline of sobriety, at least initially. I believe it
opinion is that?
Pete Reed, he was the expert who testified on behalf of Forensic Fluids Laboratories. All the parties stipulated to his qualifications and expertise.
No, I mean, who testified that a random test a month aren't enough for this particular person?
Mr. Reed,
He did, okay.
yes. He wasn't, I don't recall if he was testifying with regard to the father in this case specifically, or if he was just saying best practice to establish a baseline of sobriety is 2 to 3 random tests a week with, an eventual relaxation. But father in this case never established that baseline sobriety in this case. And I think that was a big part of the reason why the board found that it was in the child's best interest to be in the permanent custody of the agency. That and there were other indications that father had been less than forthcoming with the court. During the final hearing, he testified that he believed his positives in both November and December of 2021 were the result of one single use of an illicit substance at a party that was laced unbeknownst to him. And that was notwithstanding the expert testimony that said, given the type of testing that the agency was doing, that likely would have been out of his system within 4 or 5 days. There were additional concerns that the agency had, and the agency was also concerned that father really did not have that strong of a bond with his child. There was testimony by the visitation specialist that indicated that although that number, 64 of 71 Zoom visits, sounds like a very high average, those Zoom visits are by Zoom, and there's testimony indicating that in-person is always preferable in cases like this to help kind of establish and cement that parental bond. But of those 71 Zoom visits that were offered and the 64 that father exercised, many of them, the vast bulk of them actually were only 15 minutes long. And the worker testified that during the entire time that father had been involved in the case, from October of 2021 until the final hearing in December of 2022, he had had a total of 31 hours of visitation.
But if I recall, maybe I'm inaccurate here, but I thought there was something in the record about, the child's age. 15 minutes for a Zoom visit was related to the child's age.
That, yes, the child in this case was young. I believe he was 2 when father initially got involved, and then he was 3 by the time they had concluded. It was reduced to 15 minutes because of the child's age, but even before that August 2022 hearing when it was reduced, and part of the reason was the age, Your Honor. Another part of the reason was that father had requested additional Zoom visitations per week. So the agency had initially offered 1 in-person visit per week, every week. And there were a total of 22 offered, but 22 were offered because that's, how long father was on the in-person visitation schedule. Had father remained on the schedule, he would have initially received those 2-hour per week visits, and then over the normal course, I believe there was testimony to this effect, visitation often increases, including being relaxed to unsupervised visitation and eventually to being more or less unrestricted, home visits, overnights, extended visits, things of that nature. Even with the relatively increased number of visits, there was testimony that the amount of raw time that father spent with his child was less than 48 hours. So we would question very seriously whether father's bond with the child was that strong. The child did call him dad, and father in this case, one of the things that is in the testimony that he managed to engage the child for the entire duration of the visit when he was doing it by Zoom and also in person. But in terms of being able to establish a bond with the child, it's very difficult to suggest. My position would be that it would be very difficult to suggest that that was established and cemented through the course of so little raw time. Most of these arguments are also applicable to the second assignment of error, which would, be the manifest weight of the evidence. And partially with regard to that, I would say that Chief is a much better attorney than I am. I don't think that it was the trial court, having been on the bench for a significant amount of time and having lots of experience with these types of cases, and a better attorney on father's side had lost its way in this case. I would submit to your honors that it was the facts that won this case, and not my persuasive ability or any sort of confusion about the ICPC or its applicability, because as I already noted, it's a question of, the court made its decision with regard to the best interest factors independently of the applicability of the ICPC, and it's for those reasons that we would argue for affirmation in this case.
Thank you.
Thank you.
Thank you both for your presentations, very helpful. The court will take the issue under advisement and issue a decision in due course. A copy of the decision will be mailed to you on the day that it is released by the Clerk of Courts, and the opinions will also be posted on the Ohio Supreme Court website. The court is now adjourned.